There has been an absolutely colossal shift in the way that the Florida Family Law Court now looks at timesharing. If you're seeking to modify your timesharing plan, in other words, your final judgment and parenting plan in Florida, you now have a better chance, in my opinion, of getting past what we call a motion to dismiss. Normally, the first thing that happens is you will file a supplemental petition to modify timesharing, i.e. the final judgment. From that point forward, the other side will generally file a motion to dismiss unless they also seek a modification of timesharing. And that motion to dismiss used to be based upon a three-part test initially. One, do you have a substantial change in circumstances? Is it a material change? And third, and perhaps most important to that analysis and that threshold test, were those circumstances unanticipated since the time of the last final judgment entered in your case? Suppose that in 2015, you and your spouse had a parenting plan created and entered by the court through your final judgment. From that point forward, lots of different things happen, some substantial and some material changes in circumstances, but perhaps none of those are unanticipated. Maybe in 2015, your child had behavioral problems, or maybe in 2015, one of you had been diagnosed with psychiatric or psychological issues. That was no surprise. So trying to change your parenting plan 8 years later, however long later, trying to change your parenting plan based upon those circumstances that you already knew existed would likely lead to the court dismissing your case. With SB 1416, the big bill that changed alimony perhaps forever in the state of Florida, canceling permanent alimony, that bill, SB 14, also changed the way that Florida courts must address modifications of timesharing. In this case, the standard has now been changed. You only need to have a substantial and material change in circumstances to get past a motion to dismiss, to reopen your case to modify timesharing. The unanticipated change in circumstances has been done away with, like permanent alimony. That part of the test does not exist. That may open litigation considerably. Many more people may be able to change their parenting plan, and the defense against it may not be quite as stringent. Thank you.